Number 57, Ontario versus Samsung. Counsel?
Good afternoon. Jacob Buchdahl of Sussman Godfrey for the plaintiff appellant. I'd like to reserve 3 minutes for rebuttal.
You may, sir.
May it please the court. This is a case about freedom of contract, specifically about the ability of commercial parties from around the world to choose New York law to enforce their contracts. Our client...
Aren't we looking to intent here? Isn't that what it's all about?
Absolutely.
Okay, so in doing that, it seems to me nobody here has argued, okay, that well, we intended this and we intended that, and there should be extrinsic evidence of our negotiations or something like that, and then we can determine intent. It seems to me that what is being argued is that given the language of this contract, we can determine, as a matter of law, what was intended. Is that a fair assessment?
That is absolutely right, Your Honor.
Okay, all right. And so in doing that, it also seems to me that it depends on what we mean by that language. So when there's a very broad choice of law provision, right? And it talks about substantive and procedural law. I think everybody agrees on that. So doesn't it kind of boil down to what 202 is? Is that a procedural law that then applies according to the language of your agreement? Or is it something else? Is it a pure choice of law provision that maybe might result in some other application, or is it some combination of the two? So that's where I start. So if you would just address that.
And I think that's exactly the right place to start, because in the ministers and missionaries decision, the question is there a statutory choice of law directive that would apply here absent some choice of law provision that the parties put in their contract and therefore indicated their intent to select New York law. So as you said, what is CPLR 202? And we submit there's no question that this is a statutory choice of law directive, because when you look at CPLR 202, it asks you to look at the law of this jurisdiction.
Yeah, but aren't you leaving out the fact that in ministers and missionaries, the EPTL provision that was being referenced was a statutory directive that arose out of the common law, and this statute, Section 202, did not arise out of the common law. In point of fact, it is in derogation of the common law, specifically Lex Fori. And so the question for us then is not so much the nature of 202, but whether or not we want to extend that holding.
Well, first of all, you're certainly correct that the law from the Estates and Powers and Trusts law that was found not to apply in ministers and missionaries came out of the common law. But footnote 7 of that decision actually said that the court was not primarily relying on the origin.
Always a dangerous thing, though, to have the footnote swallow the decision.
Well, it's not.
It's a danger in this job. I recognize it. I think we all do. But it's something that usually our holdings are our holdings, and our footnotes aren't generally our holdings.
Well, I don't think that you need to somehow rely just on the footnote, because the question, right, is not what is the title of CPLR 202, what is the caption of that, or how does it appear in the statute books. The question is, what does it ask you to do, and is that consistent with the party's intent? Because 202 says that for a non-resident, recall it only applies to non-residents, you have to look and compare the statute of limitations from this jurisdiction to the jurisdiction where the cause of action accrued. And you may, depending on how that comparison goes, decide to apply, right, or borrow the statute of limitations from another jurisdiction. And what that is doing is giving you a choice of law that's based on a statute.
Look,
and that's exactly what minister.
Well, exactly, I'm not sure where you're going with that. But isn't really the borrowing statutes have been viewed under the restatement, under case law in this court, case law throughout the country, viewed as just statutes of limitations? They're not viewed as part of sort of this larger area of the law that deals with the complexities of choice of law doctrine.
We submit that's not entirely true, Your Honor. I mean,
How is that not true?
because choice of law is a broad concept that encompasses not just common law ideas or common law rules, but it also encompasses different places in the statutory scheme that tell you which law to select. That argument could apply just as equally to the ministers and missionaries case, where you had a substantive law that said, depending on where the decedent dies, we're going to
Yeah,
apply.
but 202 also doesn't apply in every case, right? It only applies to a subset of plaintiffs.
That is
So
correct.
it doesn't really align even with your argument. Even if I accepted your argument, I don't think it really aligns.
Well, I think you could say the same thing about ministers and missionaries, right? If the person died in New York, you wouldn't have to worry about whether there was any other jurisdictional law that you would look to. And here, if you look at the parties, right? We had a party from Korea. We had parties incorporated in Delaware that were headquartered in New Jersey. We represent a plaintiff that is headquartered in Ontario.
Yeah,
So
but see, here's my
it should-
problem. Here's what I see as really the underlying tension in this case. You've got the borrowing statute, the purpose of which is what? To avoid forum shopping. Then you've got, as we said in IRB, the legislative desire that this court has recognized and sought to always promote to encourage certain types of plaintiffs to come and use our courts, adopt our jurisprudence in the commercial area and so forth, right? So that strikes me as there's somewhat of a tension there. And the only way I see to harmonize that is to respect the desire under 202 to avoid the gaming unless the parties absolutely agree. And I don't think you're ready to agree when you don't know if you're plaintiff or defendant.
I
And
think
that's my problem with this whole case.
so. You're correct. You don't know if you're going to be a plaintiff or a defendant. But there's no reason to believe that these parties would want the statute of limitations to turn on who brought suit.
Yeah, but there's certainly, that argument doesn't mean any more than what I've suggested, which is, sure, until you're the plaintiff or the defendant. And if you're the defendant, yeah, you want the shorter statute of limitations. And if you're the plaintiff, you want the longer statute of
But
limitations.
let's look at
So to follow up on Judge Rivera's argument, so then clarity becomes essential. Then at least all the parties know where they're going. And see, I think taking a step back to what Judge Stein said before, which I think in many ways the heart of the case, it's when we're talking about how do we determine what we mean by enforced in the forum selection clause, in the choice of law clause in the contract, then how clear do you have to be? Is enforced it's sufficient for us to be able to determine how to apply this law in this context. And it seems to me that what I'm struggling with is a lack of clarity here. And as Judge Rivera said, if he expressly put it in there, whether it applies or not, we have the clarity that we wouldn't be here.
this whole line of cases suggests that we're going to infer intent based on the words that are used. May I continue just to
Yes,
answer the question?
please.
So we know that when they choose New York law, they're choosing New York substantive law. We know when they choose New York venue that automatically brings out most of New York's procedural law. The
So,
question-
counsel, how far, when the parties choose New York law and they choose New York as a forum, how far can the parties go in altering the procedural law that our courts ordinarily apply?
So just as far as to honor their expectation that, as it was put in the ministers and missionaries case, the law of the chosen state and no other state will be applied. Just as in ministers and missionaries, it was not appropriate for them to suddenly be subject to the law of Colorado. Here, there's no reason to believe that any party to this contract, which was signed in New York on Lehman Brothers letterhead, there's no reason to think anybody would expect or intend that when it came time to file a lawsuit, it would be subject to the statute of limitations from the province of Ontario. There is nothing in the record or in the contract that would suggest that, but there is.
Unless you're the defendant, and that forecloses the action. I mean, I think
Well,
you're not really getting to my point.
That would be a windfall for that defendant, and it seems to me that just as every one of these cases has sought to impose clarity and certainty and predictability, there's no better way to do all of that than to say that 202, just like EPTL 3-5.1b2, we're not going to send you to another state's law to figure out how to interpret this contract. We're going to do it just with the laws here, a 6-year statute of limitations.
Thank you, Counsel. Counsel?
Thank you. Good afternoon. May it please the court. My name is Grant Hennessian of the Baker McKenzie firm. We represent the appellants in this matter.
Could the parties here have contracted to a 6-year statute of limitations for everyone?
They contracted to New York law.
Could they have
Could
contracted?
they have? We don't believe so. We
Why?
think the 201 does not, well, on its face, and I think it's the Kastner case from 1979 by this court, says parties cannot extend the time for limitations prior to the accrual of the claim.
But New York law provides for a 6-year statute of limitation. If we're not looking to any other court jurisdiction's law, it's 6 years, so you wouldn't be extending it, you'd just be applying what New York law says.
But for this choice of law clause, there'd be no argument that 2 years applies under New York law. The parties would be extending that to 6 years by choosing 213 and not and avoiding
Well,
202.
really, the language of those statutes and the cases is about where you move that dial on accrual. That I'm not really understanding
Well, I
your
don't think there's any
argument there.
issue. I don't think there's any issue that this claim accrued in Ontario. I don't think there's any issue about that at all.
But can I just follow up on something that Judge Rivera raised, and that is that intention, it's hard to know what the intention would be when you're executing the agreement because you don't know who's going to be plaintiff or defendant, but isn't that the very thing then? You don't know who the plaintiff is going to be and what that jurisdiction's statute of limitations is going to be.
I don't
Isn't that
agree.
right?
I fundamentally disagree with the idea that there was any misunderstanding, or could have been, by anybody knowledgeable about New York law, about what New York law meant in 2008. At this time, you had 3 decisions of this court that said, including one in the Smith-Barney-Lucky case, that had the magic word enforced and applied the borrowing statute. And there's also the insurance
Well, it sent it back to
company
the-
against
to-
ABB.
Didn't it actually send it back to the appellate division to determine whether the borrowing statute
It
applied?
referenced the borrowing statute, and then the appellate division applied the borrowing statute. But 202, the borrowing statute, is referenced in this court's decision in the Lucky case. And there was no argument that it didn't apply.
So is it your position that at the time what the parties understood was that 202 always applies?
There would be no basis for it not to. There was no suggestion that it wouldn't. There's nothing in any case that's been cited here, there's nothing in any case
But
that
your
we know
argument is a little
of.
different, really. It's that even if they understood that, they couldn't have done anything about it contractually.
I think 201 exactly would have prohibited them from lengthening the statute. 201 on its face says that they can shorten
And
it,
by
but they can't
lengthening, you mean lengthen the foreign statute.
lengthen the
the
otherwise
Ontario statute,
applicable
for example.
statute, whatever it turned out to be. Here, if you have an Ontario, this is quite correct. There are different parties whose claims would accrue in different places. But if you were to take any of those and lengthen them to 6 years, if the contract had said we're going to apply the 6-year statute and the claim accrued outside the state and it was contrary to 202, 201 would prohibit that, as interpreted by the Kastner case.
Which then you mean to argue that even if they wanted, or even if the parties wanted to do this, they could not say, we want New York law to apply except 202, everything but that.
It's very interesting in the papers of the appellant here, in responding to that argument, the cases that they look at are cases where New York has applied substantive law of other states that is not in the New York substantive law. The principal case here is Wellsback, where Florida has a pay-when-paid provision, which we don't have in New York. Question is, will New York apply that? And the answer is yes, it's not fundamentally against our public policy. This is New York law that they're seeking to set aside. which there's no case that suggests that the parties can do that. 201 has been
Well,
part
does
of.
it make any difference if we were to conclude that 202 is not a procedural law strictly, it is a choice of law provision? Does that make a difference?
I don't think it should. I don't think it should, because I don't think,
But it might.
well,
Well, because
the courts have, this court has consistently said that this is part of the statute of limitations law. This insurance company of North America, against ABB, particularly said this, and said this applicable law clauses don't override 202. It said the state's procedural code requires that a court, when proceeded with a cause of action accruing outside New York, should apply the limitation of the foreign jurisdiction. This is a 1997 case. This case was in front of everybody when this contract was signed in 2008. And I think importantly, that case, insurance company against ABB, talked about one of the purposes of the borrowing statute is not just to prevent forum shopping, but to provide this clarity and certainty in the law. One of the reasons New York is such a treasured commercial center is because we have a stable rule of law here. We're not constantly changing the rules of the game
So
with
you mean
respect to
certainty
parties.
that you know that the rule that's set out in 202 applies as opposed to certainty in the outcome
Yeah, of course.
of the
You
application
know-
of the
you know
rule?
the 202,
Which
you
is
know
what
there's
he's
a borrowing
arguing,
statute,
which is,
of
I think,
course.
what they're arguing, which is we want certainty in the outcome. As in what statute of limitation applies specifically.
This comes, in my view, as I said in response to the question about 201, I don't think that the parties can choose a statute of limitations, given that the legislature has enacted 202 as part of our statute of limitations, and given that this court has said that choice of law clauses don't override that.
You mean you can't choose one that would be longer than what would apply if 202 applied?
Prior to the accrual of the claim. And this question was exactly before the court in the Kastner case in 1979. So they're asking you to reform not just 202, but also 201, which are the first two articles, first two sections of Article 2. I mean, to say one looks at 213 and doesn't look at 201 and 202, to me, doesn't make any sense. Every New York lawyer, certainly one that advises on disputes, knows about the borrowing statute.
Let's say we disagree with you on what you have set out now as this per se rule that parties could never make this choice. Let's say we decided they could make this choice. Why is it in this case they did or didn't make this choice?
Well, because we know that in 2008, when they entered into the contract, the cases they had before them were the Lucky case, and again, this insurance company against ABB case. And these cases, one involving these so-called talismanic words of enforceable, in the Lucky case, applied the borrowing statute. And in the insurance company case, they said, notwithstanding the fact that you've chosen a foreign law, we're going to apply a borrowing statute. That is part of the law. It is part of the law. There's really not a policy reason to read it out, in my opinion. And there's no reason to think the parties intended to read it out. There's no basis in 2008. This is well before ministers and missionaries. It's well before IRB.
Well,
I don't see how a lawyer could predict these things.
ABB also talked about the purpose being to prevent forum shopping, but when you have a contract with a choice of law provision, how does that apply?
Choice of forum.
I'm sorry.
Choice of, yeah, sorry.
Well, one thing to be clear about is these cases, I think, are all considered to be choice of forum, choice of law clauses. You're reading the choice of law. Choice of New York law will mean substantive law. I think this was what was going on in IRB and also in ministers and missionaries. And we're going to apply the substantive, the parties choose New York law. We're going to give them the substantive law that they intend to have without regard to these common law or even statutory conflicts regarding the substantive law. One of the interesting things about ministers and missionaries is it
But
never
you're not relying on that substantive procedural distinction here.
Well,
I thought that the parties had agreed that you weren't. I may be
no,
wrong.
ministers and missionaries uses the word procedural 16 times, or substantive law 16 times. The dissent uses it 21 times. It doesn't directly confront this issue of substantive against procedural, in my view. And you have this question about what would it mean to extend it to procedural. The CPLR has 60 different articles. How many of these now will come into?
I can only tell you the way I'm looking at it. The way I look at the word enforce and the way I understood both of your arguments is that you both were saying that substantive and procedural law was included within the word enforce. We're on to the next question, which is the application of 202 and whether or not it's in derogation of the common law or part of it. So, see what I'm saying?
I have to say I don't quite.
Okay. I just want to be clear in my own mind. Are you relying on the distinction between substantive and procedural enforce for your argument?
Let me answer you in this way. The cases that have been before this court that touch upon what enforcement or enforced means have been arbitration cases. The Lucky case, the
TIRAC, there are a
diamond
number of them,
waterproofing, yeah, TIRAC, yeah. The question there was actually a gatekeeping issue. This is a very complicated part of law. This arbitration, who should decide things like statute of limitations or who the parties are to a contract providing for arbitration. And what these cases have said is if parties say their contract is to be enforced under New York law, then our courts will decide it under the CPLR Article 75 and not the arbitrator under the Federal Arbitration Act. That's all this court has looked at with respect to this procedural, so-called procedural substantive distinction. To take the holding of ministers and missionaries and extend it to the CPLR generally, I think, would be a leap,
Thank you, counsel.
Thank you.
Counsel?
So the question is whether the parties can make that extension using the word enforce, right? That's what we're talking about. Right. They've selected the substantive law. They've selected their venue. They've written the broadest choice of law clause they can. They've used this word enforce, which many courts have said brings in statute of limitations questions. Not this court yet, but certainly lots of lower courts have said if you have the word enforce, and the appellate division just agreed, this would bring in statute of limitations questions. So what more can they do to signal their intent that they want New York law to apply? And it really is, if it's not entirely, it's certainly not a big leap from ministers and missionaries to say that just as in that case, you shouldn't be randomly subject to Colorado state law, you shouldn't here be subject to Ontario statute of limitations law.
But at the time that the language is drafted and the parties sign off on it, it predates those cases. So you're left with, as your adversary suggested, a different line of cases that, if it's not expressed, certainly suggests that you'd have to do more than say what the clause says to make clear that you are trying to carve out the application of 202.
These cases don't change the law. They simply interpret the intent of the parties. Whether it's IRB Brazil or ministers and missionaries, they both say, we're going to let parties select New York law, and we're not going to make them be subject to conflicts of law rules. We're not going to make them be subject to statutory choice of law directives.
Why did this court send it back in matter of Smith-Barney for application of 202 and potential tolling provisions that might apply?
The question simply wasn't directly presented to the court. Was that an oversight? It may well have been, but it was not briefed below. One of the litigants was pro se. No briefs were submitted to the appellate division upon remand. So it's not a question that had ever been clearly decided by anyone, but what is clear here is that they tried to draft the broadest possible choice of law clause, and they should not, as a result of that, be subject to a Canadian statute of limitations. It does not make sense that commercial parties would sit down in New York and say, well, if you sue, you've got the Korean statute of limitations, 5 or 10 years. If you sue, you've got Canadian. If you sue, you've got Delaware, 3 years. If you sue, you've got New
But
York, 6 years.
202 is longstanding, and as the adversary makes clear, this is reflecting a strong public policy.
Well, but the policy, as one of you pointed out, is to avoid venue shopping, right? Is to avoid forum shopping that would somehow game the system. Here, no one's doing that. Everyone knew the case was going to be litigated here in New York. And then the question is, if that's already accomplished by a venue selection clause.
Litigated in New York if you're not time barred.
Absolutely, but the
Which is,
question
we're
is.
back to the problem.
Right, but
I
if you
pointed out.
already have the venue, and you already have the procedural law that comes with that venue, what else does enforced give you? It has to give you the statute of limitations, or it adds nothing to the contract whatsoever. And the word enforced, we know, is supposed to have some effect. That can't suddenly become meaningless.
Thank you, counsel.